now, which I understand was initiated by the Republic,
Yes, Your Honor.
should be withdrawn.
That was a procedural difficulty that the Court of Appeals tried to decipher, and my understanding is at that point we were going to freeze everything. In deference to the
I'll
court.
reserve the question
Yes, Your Honor.
for the Solicitor General to answer. No. In the meantime, I'm done with counsel. Thank you very much.
Thank you, Your Honor.
Any more questions? Ternan, just one or two clarifications.
Yes, Your Honor.
You have put forward a few points that are quite novel and which go into the heart of, I think, a question that even benefits the government.
Yes, Your Honor.
What you're effectively saying is that the government made a mistake in appropriating or expropriating a property which already belongs to it.
I believe so, Your Honor. And you know, it's not actually that simple. The land is owned by the BCDA.
The government.
Yes. There are 4 petitioners to the expropriation case. The Executive Secretary, the DOTC, the MIA, and another one. None of them is the BCDA. So you will end up with the BCDA owning the land and some other entity owning the structure, and it's not specified who will own the structure.
Well, the executive department can trace that out. Point is, it's the government.
Yes, Your Honor.
The government owns the land, and according to you, it already owned the building
Yes, Your Honor.
based on the build and operate, BOT, build, operate, transfer.
Also on the general principle that the accessory follows the principal, Your Honor.
That might be wobbly, but that might be wobbly because you have a big structure there allowed by the government to be constructed.
Yes,
so you
Your
could
Honor.
also say it's a question of good faith and bad faith. But the point you're trying to drive at is that expropriation is used only when the owner is a private party who is innocent.
Yes, Your Honor.
It just so happened the government wants the property and the innocent party has no choice but to give it
Yes, Your Honor.
in order to serve public interest.
Yes, Your Honor.
That's what you're saying.
Yes, and that is why the compensation standard favors him.
Yes. In this case, why should there be expropriation in the first place when the property belongs to the government, and in the second place, even if it does not, the government should not make the party, in this case Piatco, earn
Yes,
or
sir.
profit. The best scenario is just pay what it has spent reasonably without profit in quotation marks.
Yes, Your Honor. The literature that I have read focuses on the benefit received by the government. So although the term is unjust enrichment, the proper term should be really benefits.
In fact, did the government have to take over that terminal?
No, I don't think so, Your Honor.
It was not forced to take it over.
No,
it
it
could
was
have
not.
just folded its arms and built another terminal.
Yes, Your Honor.
In other words, just leave the parties where they are after the court in Agan declared the contract with Piatco void.
As a practical matter, Your Honor, I would have relied on what negotiation theorists call the BATNA, or the best alternative to not having an agreement, and just told Piatco, listen, take $350 million, which is the cost, or take it away.
Yes. Or in Agan, that was a decision written by Justice Puno, where I concurred and wrote a separate opinion. That was before I was Chief Justice, as you realize. And we said that the contract was void.
Yes, Your Honor.
And that, however, the government cannot enrich itself at the expense of Piatco. So therefore, it's entitled to quantum merit payment.
Yes, Your Honor.
All right. The government, in turn, said, well, we would like to expropriate, and therefore filed that case in Ginguyon, and that case reached the court itself.
Yes, Your Honor.
And the court granted the petition of the government.
Yes.
Now, even if this court now wants to adopt your theory, is it not barred from doing so when the decision in Ginguyon is already final?
think, Your Honor,
Not only final, but partly executed.
that would depend, Your Honor, on how we appreciate the theories of issue preclusion. And the argument of the Solicitor General is simply law of the case. There are other theories of preclusion, stare decisis.
Yes, what is the theory then that this court may adopt
Yes.
to follow your prayer?
There is one prevailing premise that permits a preclusion, whether it's stare decisis, res judicata, or anything. And that simple premise is that there has been one full and fair opportunity to litigate the issue.
We're interested. I think Justice Puno would be interested because he and I and a few others dissented from Gingoyan precisely because we did not agree that the solution was expropriation, but was just quantum merit payment. However, we are bound, even if we were minority in Gingoyan, by the majority's opinion in Gingoyan. And we cannot, just because we were minority, run roughshod of that
Yes, Your Honor.
position. We have to have a valid reason, a valid position or theory that will stand not only Philippine scrutiny but international scrutiny. There being two other bodies that may look into this, unfortunately. No?
Yes, Your Honor. If Your
So
Honor,
our theory, in this case, your proposed theory must be very strong for us to be able to navigate the risky waters spawned by the government's position in Gingoyan, which this court adopted.
yes, Your Honor. If Your Honors will not accept my theory that the issue has not been precluded, Your Honors you also might want to consider that even res judicata has exceptions. And when it has to, and when the use of res judicata results in a manifest injustice or would violate public policy, then res judicata need not be
In your
applied.
memorandum, will you please discuss that also from the international point of view?
Yes, Your Honor.
You see, this has repercussions in both the Singapore and Washington arbitral bodies. Not that we will surrender our sovereign prerogative as the Supreme Court of the Philippines, but that we must also be sure that whatever theory you propose and we adopt will stand international scrutiny.
Yes, Your Honor.
All right? There being no other question, we will now excuse you and we will hear the Solicitor General.
Thank you, Your Honor.
You have 15 minutes, Mr. Solicitor General.
Thank you, Your Honor. May it please this Honorable Court. In GR number 169914, Petitioner AEDC prays that after due hearing, judgment be rendered, commanding the respondents, their officers, agents, successors, representatives, or persons or entities acting in their behalf to formally award the NAIA IPT3 project to petitioner AEDC and to execute and formalize with petitioner AEDC the approved draft concession agreement embodying the agreed terms and conditions for the operation of the NAIA IPT3 and directing respondents to cease and desist from awarding the NAIA IPT project to third parties or negotiating and entering into any concession contract with third parties. We respectfully submit, Your Honors, that the prayer should not be granted. And we invite attention to the following main planks of our arguments. First, that the BOT law is no longer applicable. Second, that mandamus is not a proper remedy. And third, that in the event this Honorable Court should grant or issue the writ of mandamus, the issuance of such a writ, given the fact that there is no longer a BOT project and that no contract exists, no BOT contract that is execution ready exists, then absurd, if not unjust consequences will result. On the first, the BOT law, Your Honors, cannot apply if there is no BOT contract. And the BOT contract has been declared null and void. Under the BOT law itself, a BOT project contemplates an infrastructure or development project for which the government needs private sector resources in order that the construction, operation, and maintenance may be financed, and that government determines that the private sector financing for this infrastructure or development project is to be repaid by authorizing the private sector project proponent to charge and collect tolls, fees, rentals for the use of the project facility or a share in the revenue. This arrangement is supposed to be embodied in a BOT contract as defined in the BOT law itself. In the instant case, no BOT contract can be executed because the elements of such a contract no longer exist. First, there is no more infrastructure facility to construct, as required in the definition of the BOT arrangement, because there is already a terminal that has been built. Second, there is nothing to finance by a project proponent, inasmuch as government apparently is no longer interested in such a financing. Third, there is no operating right to transfer because government obviously intends to operate it on its own. And fourth, there is no facility which the project proponent can transfer to government because it is government that is acquiring ownership over the facility. The declaration by this Honorable Court of the absolute nullity of the concession contracts and the supplements in AGAN versus Piatco, together with the fact that the NAIA Terminal 3 facility already exists, therefore removed it from the purview of the BOT law. The right to operate a public utility, such as the passenger terminal, can be granted only through a franchise by the state. This franchise can be given directly by Congress or by the government agencies vested by Congress with the power to grant a franchise. In the particular case of an international passenger terminal in the NAIA complex, the right to operate is granted exclusively to MIAA, Manila International Airport Authority. The only exception is when a valid BOT contract is executed covering the concession to operate the terminal within NAIA. Until that BOT contract is perfected, no operating rights can be granted nor sourced other than through the traditional modes of issuing franchises. Thus, when this Honorable Court declared the concession contract and its supplements null and void, it removed any and all vestiges of the application of the BOT law, since the nullified concession contracts were the only documents containing the purportedly legally enforceable obligations of government. There is no other legally enforceable document whereby the government can be compelled to enter into another financing agreement with the private sector for the acquisition or operation of the terminal. This situation becomes even more clear when we consider that when AGAN became final, the terminal was already built. The entire premise for the NAIA IPT3 project, which is construction of a terminal from ground up, as then approved by NEDA ICC, had completely ceased to exist. Government cannot then be put back in a position of a seeker of private BOT financing. Thus, we say that the BOT law does not apply. Then we have the subsequent act of government in expropriating the terminal. this subsequent act of expropriation all the more removed the NIA and the NAIA IPT3, including the issue of the operations of such a facility from the ambit of the BOT law. It need only be remembered, Your Honors, that the eminent domain is an inherent power of the state and its exercise is a matter of sovereign discretion, subject only to compliance with public use, payment of just compensation, and due process of law. It is a proceeding in rem that acts upon the property. And in this connection, may I just quote from the dispositive portion of Republic versus Gingoyon, where this Honorable Court said, petitioners upon the effectivity of the writ of possession are authorized to start the implementation of the Ninoy Aquino International Airport Passenger Terminal 3 project by performing the acts that are essential in the operation of the said International Airport Passenger Terminal project. By affirming the right of government to expropriate the terminal and recognizing its right to operate the same upon the effectivity of the writ of possession, this Honorable Court pronounced the right of government to operate the terminal and thus place it beyond the reach of any action in personam as prayed for by the petitioner in this case. And to respond to Attorney Bernas, expropriation is not an admission of liability in the arbitration case. In fact, we raised this in exceed precisely, and contrary to his representation, there is no provision in the Republic of the Philippines, Republic of Germany bilateral investment treaty that says that expropriation is prohibited. In fact, as I said, we did raise this as a defense precisely in exceed itself. All right. Second, the petitioner's prayer to be awarded the BOT project is not proper through mandamus. As previously stated, there is no longer a BOT project. Therefore, the petitioner has really no established right to enforce. Mandamus will issue only to establish a right. This Honorable Court said, will not issue to establish a right, but only to enforce one that is already established. The petition for mandamus in this case prays that respondents be compelled to execute and formalize the draft concession agreement. We submit that this cannot be done through mandamus because equally well settled is the rule that mandamus will not lie to compel the performance of an obligation arising from a contract, much less create a contract. AEDC has not shown any exclusive, clear, and vested statutory right to the writ of mandamus. Section 4, which was supposed to be the basis of this right, Section 4A of the BOT law grants only the right to match. This is the only real recognized right granted to the original proponent, the right to match a more favorable proposal submitted by another. Rule 10, which was also mentioned, says only may. The only use of the word shall in Rule 10.1 refers to a matched bid, where the original proposal exercises the right to match the highest or the most favorable bid. Only then will there be only there do we use shall. All right, third, if the mandamus is granted, then certain absurd and unjust consequences could result. One, the Honorable Court will award a BOT contract that no longer exists. 2, a writ of mandamus to execute the draft concession agreement. If a writ is issued, there will be no complete resolution because there is really, the draft concession agreement is an incomplete thing. It does not contain the real terms of the contract for the operation of the facility. You have to go to through negotiations, you have to go through certain approval authorities, and so how will the writ of mandamus then compel our respondents when they still have to negotiate on what the terms of the contract should be? Third, maybe this is a case filed against the wrong parties. Because if it were to be mandamus, you have to compel also NEDA. You have to compel the Investment Coordinating Committee. You have to compel the the Cabinet Committee. And you may have to include the President, the Secretary of the Finance, the Secretary of Trade, among the parties to this case. And of course, we submit, as already mentioned earlier, that a grant of the writ of mandamus will reverse Gingoyon. And it will, in effect, infringe on the government's constitutionally protected freedom to contract. And so, mandamus will not lie. What do we suggest as relief for petitioner AEDC? The relief could be found in proceeding against those people who may have created the environment that produced damages for them, including, all those who have probably been responsible for the damages sustained by AEDC. Thank you very much, Your Honor.
Thank you, Mr. Solicitor General. Questions? Justice Corona.
First things first, Mr. Solicitor General. I recall the President at one time before declaring that the government was going to concentrate its resources on making the Diosdado Macapagal International Airport in Clark operational. If that is the case, then what is the interest in this NAIA 3 now? What's the urgency now?
Your Honor, the President, I also heard the President say that her strategic objective is to open NAIA IPT Terminal 3. And so it seems that pending the start of the construction of and the improvement of the Clark Airport Terminal, maybe we need to have this operational just to be able to, to provide a what the President calls a show window, perhaps. And this is the first thing that our tourists are supposed to see, the facilities we have in our airport.
Was it a bargaining chip before the Gingoyon decision?
Your Honor?
Was it a bargaining chip?
I heard that only a few months. I was very new as Solicitor General then when I heard the President say that her strategic objective is really for the operation of the terminal.
Second question, Mr. Solicitor General. What is the effect of the payment of the proffered value of 3 billion pesos on 174166?
Your Honor, that the other case really should, having paid because the Court of Appeals on its own withdrew or lifted the temporary restraining order, which was really the subject of the petition we filed before this honorable court. It may have been just that we have failed to withdraw the case. I personally, at this point, I really would have wanted to have the case withdrawn, Your Honor.
So we can now dismiss AGR 95539. Is that what you're
This
saying?
is the Republic of the Philippines versus Court of Appeals and Baterina. Yes, Your Honor, there is no more reason for that.
Yeah. Can you explain to us what are the effects of this payment on the cases in the international agencies, the international arbitration courts?
Yes, Your Honor. Insofar as the international arbitration dispute being heard by the ICC in Singapore, this was precisely one of the things that the ICC directed the government of the Republic of the Philippines to do before, if it were to be given a writ of possession, and the Republic, of course, manifested even before the tribunal that we were in possession of the facility. It became necessary even then to effect payment of the preferred value. Now, with respect to the exit case, we also manifested that expropriation has been undertaken by the Republic of the Philippines, and that we are ready to comply with the Philippine laws on expropriation, and that is something that, of course, we will assure this honorable court about. Only Philippine laws will, of course, govern the matter of the expropriation. So somehow the payment of the 3 billion pesos preferred value manifested good faith on the part of the Republic of the Philippines in dealing with this.
Can you comment on the statement of Attorney Bernas to the effect that if the Philippine government loses the cases in Singapore and in Washington, the government stands to be liable for almost $1 billion US?
Your Honor,
Is the government in a position to pay this just from the income of that airport alone, considering that I think the government has to be paid also 20% of the revenues on a per annum basis?
I don't think so, Your Honor. I don't think the government will pay. I am confident that there will be no such adverse finding by the arbitral tribunals, Your Honor. In ICSID, the claim of rapport is something like 425 million US dollars. In ICC in Singapore, the total claim of Piatco is something like 560 million US dollars. That's why it is true that the combination of these two claims would reach as much as 1 billion. But I don't see any possibility for that, Your Honor. You see, our forensic auditor, our forensic accountant, who went over the documents relative to the claims of rapport in ICSID, were actually made a finding that insofar as expenses of rapport supported by documents are concerned, the total expenses do not exceed 44 million US dollars. And when the same forensic accountant checked the Piatco documents presented before the ICC tribunal in Singapore, the maximum, from the documents anyway, our forensic accountant said that the maximum amount covered by all of these documents is something like $166 million.
So you
That
mean
is too far away from $1 billion, Your Honor.
So you mean Attorney Bernas is just exaggerating?
No, Attorney Bernas is pessimistic. He feels that we will lose the cases and the award will be to the maximum insofar as the claims of Fraport and the Piatco are concerned.
But not realistic.
Yes, if we are to be realistic about this, I don't think that an amount even approximating half of that will at all be the liability of the Republic.
Thank you.
Thank you, Your Honor.
Other questions from the court? Justice Nazario.
Sir, I only have just one question.
Yes, Your Honor.
Will it be all right to say that if there is no specific law prohibiting the automatic award of the contract to the original proponent, when the contract with the second proponent had been nullified, then it could be done?
I'm sorry, Your Honor. I do not agree. My position is the original proponent who lost in the bidding because he could not match the most favorable competitive or comparative proposal that was submitted, even if eventually after the lapse of how many years the Supreme Court declares that the contracts are null and void, must be able to show a clear vested statutory right in order to be entitled to the prayer that the proponent brought to this honorable court. So, where no law exists, I don't think that the proponent is entitled at all to the relief prayed for.
No, if there is no law prohibiting.
Even if there is no law prohibiting, if there is no law that actually grants the right, Your Honor.
Thank you.
Thank you, Your Honor.
There are no more questions from the court, in which case the Chief Justice has one question.
Yes, Your Honor.
Attorney Bernas said that the Solicitor General may have made a mistake, or at least have a legal strategy that is disadvantageous to the government when it filed the expropriation action in the Pasay City Court. Because by expropriating, the government stands to pay more than what may have been ordered by this court in Agan, which was quantum meruit. And second, it has placed the government at some disadvantage in the arbitral tribunals in Singapore and in Washington. I know you were not yet the Solicitor General at the time that these actions were instituted, but I would like to get your comment on that submission by Attorney Bernas. Because whether the government eventually ends up with the terminal or it is given to AEDC, this amount will still become material, isn't it?
Yes, Your Honor. Looking at the decision to institute expropriation proceedings from hindsight, Your Honor, there may be merit to what Attorney Bernas says. But one must look at this in light of what the actual facts were at the time the decision was made. There was need for government to take immediate possession of the facility. And the only way, according to the people who then made this decision or who made the advice, they said that the easiest, fastest way to do it would be to file a petition, a complaint for expropriation.
Would not
Because
the easiest have been an execution of the Agan decision?
Well, unfortunately, that was not what was considered, Your Honor, by the people who made the decisions.
If you agree then with Attorney Bernas, can you also recommend a way by which this court may be able to get out of that decision, affirming or granting your petition for expropriation?
I am sorry, Your Honor. At this point, I believe that the Gingoyon decision is correct 100%, Your Honor.
Is it correct because the Supreme Court said so?
Because the Supreme Court said so.
Thank you very much, Mr. Solicitor General.
Thank you, Your Honor.
Now we have finished with the oral argument. The parties would be required by the court to present or submit their written memoranda within how many days, parties? Normally it's 20 days, but ilan? 15 days.
Yes, Your Honor.
15 days. All right. Parties are given 15 days from today within which to submit their respective memoranda, incorporating all their arguments, whether said verbally or not, and also pertinent documents required during the course of the oral argument. With or without this memoranda submitted within 15 days by the parties, the court will deem the case submitted for resolution. With that order, the session is now adjourned.